You brought a lawsuit against your doctor claiming that he was careless. And now you have been told that you have to appear for what's known as a deposition. And you're wondering, is your deposition, your question and answer session, is that going to be videotaped so that it is shown to the jury at a later time when your case comes up for trial? Would you like to learn the answer? Come join me for a moment as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, you find out that you have to appear for what's known as a deposition, which is really nothing more than a question and answer session that takes place in your attorney's office. And it's under oath. You swear to tell the truth. Now, there's no judge there, there's no jury there, but there is a court stenographer there to record all of the questions that you are asked and all of the answers that you give. And you should know something. The answers that you give in response to the defense lawyer's questions carry the same exact weight as if you are testifying at the time of trial. The only difference is that this is being done in your attorney's conference room. Okay, so let's go back to the question I raised at the beginning of this video. Is your deposition going to be videotaped? And in all likelihood, the answer is no. There are very few instances where your deposition will actually be videotaped. The primary instance is where you are extremely ill and it is not likely that you will survive by the time your case comes up for trial. In that instance, your attorney will want to go ahead, videotape your testimony so that your testimony will be preserved and the jury actually gets to see you and hear you on video when you give testimony. Another reason might be if you are physically incapacitated and are not able to actually get to your attorney's office or get to court when your case comes up for trial. In that instance, we may go ahead and do a video deposition. But you should know it's not simply a matter of setting up a video camera and pressing record when you come in. We actually have to go through a procedure to notify my opponent that we are going ahead and videotaping your deposition. We have to tell them who the videographer is. We have to go ahead and explain the reason or the basis for why we are going ahead with a videotape deposition. And you should know something else. The defense has the right to object for whatever reason, if they think it's inappropriate. And there are instances where the defense has objected, and now the judge has to make a ruling to see whether or not he agrees or disagrees with the defense lawyer who is making that objection. So why do I raise this question with you? I raise it with you because this question comes up from time to time as the injured patient asks, you know, I understand I have to give testimony in this deposition, but will it be videotaped? So now you know the answer. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.